what happens when the Construction Contracts Act collides with the liquidation regime? Hello, my name's Ross Dillon. I'm a consultant at QueenCityLaw, and today we're going to look at an interesting issue when a statutory regime designed for one thing collides with another statutory regime designed for a different purpose. In this case, Construction Contracts Act and the Companies Act liquidation regime. Let's start with the liquidation regime. When a company can't pay its debts, one of the options is to place the company into liquidation. Liquidation is regarded as the formal death of the company. It is the end game. That has some particular consequences, and there is a regime designed to deal with those consequences. The liquidator, once he's appointed, is in control of all of the assets of the company, and his job basically is to realise those assets and then distribute them to the various creditors of the company. And as between those creditors, their particular interests are ranked under a schedule to the Companies Act. Fundamentally, however, the same types of creditors have to be treated equally, and that is called pari passu. They all share equally, everybody's on an equal footing. Once the liquidator is appointed, he asks for what's called proofs of debt, which is a formal statement from every creditor setting out exactly what it is that their claim is against the company. Then the liquidator assesses those and can value the claim. Now, sometimes that's very straightforward, sometimes it's quite complicated. If a liquidator values a claim that isn't the amount that the creditor claims, the creditor can challenge that through the court. But that's another process, and that's expensive. There's also the requirement that if the company is owed money and the creditor has a claim against that same company, those two amounts have to be set off, and the claim is just whatever the balance is. That's called the set-off regime under section 310 of the Act. There is one other thing that is relevant for our discussion today, and that is there are cases where a company goes in liquidation, but it's actually solvent. There is money left at the end of everybody being paid, as opposed to the usual course where in fact there isn't enough money for everybody and there's just a debt hanging over the company right at the end of the process. But keep in mind for our purposes today that there is this thing called a solvent liquidation, because in a solvent liquidation the company can actually come out the other end. It's like a resurrection after its death through liquidation. Now let's look at the Construction Contracts Act regime. Construction contracts are a source of disputes. Who should have done what and when? How much should it have cost? Those sorts of things are almost endemic in the construction industry. So we have a Construction Contracts Act that is designed to try and quickly resolve disputes, at least to a provisional level, to allow money to flow so a contractor can continue to be paid and thus can continue work on a project. But this provisional type of dispute resolution process allows for the parties to come back at some later stage and get a full, final and binding determination. So you have an interim decision which results in a payment, but the parties are able to revisit that later to work out what the final result is, where does the money finally resolved. Now that's called the pay now, argue later principle. In fact, there is a dispute resolution before the pay now, but after the pay now there is still a later when the thing can be substantively determined. This allows for construction projects to continue and for contractors to be paid with the view that there's going to be a final wash-up. The first step in this is always usually the contractor making what's called a payments claim, and he basically just says, you owe me this amount of money for this work on this job. The Act lays out exactly what the requirements of a payments claim are, but it's pretty straightforward. There are two responses to a payments claim. One obviously is payment, but if that payment is not going to be made for a reason that there's a dispute about, there is a process that is required called a payments schedule, which is a very formal answer to the payments claim. Again, the requirements of a payments schedule are laid out in the Act, but frankly it is a relatively difficult process because it has to be quite specific as to why certain sums aren't going to be paid. And obviously if there's a difference between a payments claim and a payments schedule, you've got grounds for a dispute. That dispute can go to adjudication, and the adjudicator can decide what the result is. But there are some anomalies in this process because the adjudicator doesn't have to decide necessarily what the substantive amount finally owing is. They can just decide whether a proper payments claim has been made, whether that's been answered with a proper payments schedule, and can, but doesn't have to go on to determine whether the substantive rights have been established. Which means you can have an adjudication which simply says a proper payments claim has been made. The consequence of that is that amount is immediately payable. The issue here is what happens when that adjudication determines that a payments claim has been properly made, but specifically says I wasn't asked to determine and haven't determined whether any of that money is substantively due. The Act says it's due now because it was a proper payments claim, but I haven't looked at whether, in fact, there is a substantive entitlement to payment. That's the issue that came before the court in a case where the company that the claim was made against was placed in liquidation. The case that came before the court is called Mason Thomas and another against Three Dukes Homes Limited and others. In that case, we had an adjudication where the adjudicator had said a proper payments claim has been made and this amount is immediately payable. The adjudication on its face specifically said that no determination of the substantive rights had been asked to be made or had been made in the adjudication. The effect of that is that under the Act, the money is immediately payable, but because the substantive rights haven't been determined, effectively the adjudication is saying the contractor did the right form work. He created the correct document. But it doesn't say that he's actually owed the money. It's just that the Act says because he did the right documentation, the money is payable. Now, the company that the claim was against went into liquidation. Before it went into liquidation, it applied to the High Court to try and determine the substantive rights between the parties, how much money was actually due and owing, because in the company's view, it had already overpaid. That proceeding was then used as the basis to try and stop the adjudication being enforced. That was unsuccessful, and the High Court proceeding was stayed pending payment to a third party who was going to hold the money while all these things were sorted out at a substantive level. However, with the company being then placed into liquidation, the issue for the liquidator was, can it accept an adjudication which says the substantive rights haven't been determined, in circumstances where the liquidator's requirement is to treat everybody equally? Everybody else is going to have to establish a substantive right to a claim against the company, but this adjudication says no substantive rights have been established. So surely the liquidator has to establish them. But the Construction Contracts Act says once you've got an adjudication, that amount is due and payable. So how was that dealt with? That was the issue for the court. The liquidators applied to the court saying, well, here are the issues, we don't know what to do, can the court assist us? which is one of the liquidator's powers. They can make exactly those types of applications to the court in these types of circumstances. The court looked at this case very specifically on its own facts. The fact that the company prior to liquidation had applied to the High Court, obtained certain orders, but also had its proceedings stayed, was regarded as relevant because obviously the company had not paid the adjudication, was taking steps to avoid paying the adjudication while the substantive rights were sorted out, and that's contrary to the principles of the Act. The other thing the court found particularly relevant in this case was that this was a solvent liquidation. The liquidators indicated that once all the creditors had been paid, there would still be quite a lot of money left over, and the company would then exit liquidation. It would be back in normal trading capacity. It would be able to carry on just as if nothing had happened in the liquidation. And so the effect of the liquidation would be just to deal with this dispute between the creditor and the company. In those circumstances, the court said, because it's a solvent liquidation, there will be a later in terms of pay now, argue later. There is a later where the substantive arguments can still be determined. Therefore, in the liquidation, the adjudication has to be paid. The question now is, what if this was not a solvent liquidation? What if this was the end of the line? What if there was just never going to be enough money to pay everybody equally? Would the court have determined this issue the same way? That is an open question, and for the reasons that are advanced in that judgment and dealt with in that judgment, it is likely that, in fact, the liquidator will have to assess the value of the claim being made by the creditor, even if he's got an adjudication, if the adjudication is just limited to whether a correct payments claim has been made and hasn't determined substantial issues. So the liquidator will then have to assess what is the substantive value of the claim, which could be nothing, in fact, if in fact the creditor is being overpaid through the terms of the construction contract. But it could be something else. They get into a full construction contracts dispute. Another alternative, though, is that the liquidator has the power to send the issue to adjudication to get the substantive merits of the case determined. So the liquidator themselves can use the benefit of the Construction Contracts Act. We'll have to watch the space to see what the court does with it when it's faced with an insolvent liquidation. Thanks for watching.